vicarious liability under the law of torts. I hope I'm audible. Let me know if you can hear me. Please reply with a yes in the chat box. Okay, so before we move on to discuss vicarious liability under the law of torts, let me announce a few offers that Gradeup has running. Now we have a February mailer which is running on Gradeup Super. You get a flat 50% off on your Gradeup Super subscription if you avail the offer between Feb 22 and 25th. Also, the coupon code is Feb 50. So you need to apply Feb 50 in order to avail of this discount. We also have a 2-month revision course on current affairs and legal events which is running, wherein the current affairs and legal events of last 8 months would be discussed. The enrollments are on for this course. We also have a CLAT 2021 crash course going on, and the enrollments are open for this course as well. Now we also have an express crash course going on for MHCET and SLAT 2021. You can enroll in the same as well. Now let us come to the elephant in the room, which is vicarious liability. Now what is vicarious liability? So normally when you commit some wrong, you can be tried for it, right? But under vicarious liability, you can also be held liable for the act of some other person. Now, vicarious liability arises in certain kinds of relationships. So these are principal-agent, master-servant, and among partners in a partnership firm. Now let us see how is vicarious liability treated in a principal-agent relationship. Now there's a Latin maxim which says qui facit per alium facit per se. It means act of an agent is the act of the principal. It means that whenever an agent commits a tort in the course of his engagement with the principal, both the agent and the principal would become liable. So if a principal has authorized his agent to do some work, and the agent in the course of performing this work commits a tort, then the agent is liable because he committed some wrong, and the principal becomes vicariously liable because the agent committed the wrong while performing the work which was authorized to him by the principal. Now, this authority could either be express or it can also be implied. If you like the Gradeup CLAT channel, please like, comment, share and subscribe to the same. Now, master-servant relationship. So, vicarious liability also arises in a master-servant relationship. Now, what is a master-servant relationship? So, an employer or an employee relationship is typically considered to be a master and servant relationship. Now, if you want to find out whether in your fact situation you would not be told whether the person is the master or the servant, and most of the times you would be required to figure that out on your own. So how do you do that? How do you find out whether the relationship being talked about is that of a master and servant? So you need to basically see who has appointed the servant or the employee, who supervises and controls him, under whose direction does the servant work, who is the one who is firing that particular person, who is paying the wages. So these are all parameters which you need to apply, and you need to look out for the keywords as well. So in the fact situation, there would be certain hints or clues dropped which would enable you to understand whether there is a master-servant relationship existing or not. Now, course of employment. So if a servant does a wrong during the course of employment, then the master would become vicariously liable. So you need to understand what is a course of employment. So if a servant is performing an act authorized by the employer, and if he commits that wrong, either he commits an authorized act wrongly, or the mode of performance of that authorized act is wrong, then the master would be held vicariously liable. Now partners are also vicariously liable. So partners have a similar relationship as principal and agent. So for example, if there are 4 partners in a firm, and one partner goes and swindles some money on account of the firm, then all the other partners also become vicariously liable. Now, acts committed in the ordinary course of business. So it's not that if a partner goes and murders someone else, all the other partners would also become vicariously liable. It's only for whatever wrong they have committed in the ordinary course of business of the firm. So all partners are agents of each other, and they are vicariously liable for acts committed in the ordinary course of business. Now the liability of each partner is joint and several. So each partner can either be sued independently or they can be sued jointly together. Now let us discuss a few questions related to vicarious liability. Now the principle here is, a master is liable for the acts of his servant done in due course of employment. Now principle number 2 is, express prohibition is no defense in vicarious liability. Then master is the one who controls and supervises the work of the servant. Now let us come to the fact situation. Now Anuj was Anil's friend and he required a driver for a day. Anil lent Amit his driver to Anuj. Anuj told Amit to go to various places, told him to drive at a speed not above 80 km per hour, and also gave him an allowance for the day. Amit, despite Anuj's express prohibition, drove at a higher speed and ended up hitting a rickshaw driver. Decide the liability. Now, Amit is solely liable as he did not follow the express prohibition. Now, Anil and Amit are liable as Amit caused the accident and Anil is the master and hence is vicariously liable. Now, Anuj and Amit are liable as Amit caused the accident and he was working under Anuj's directions and control, and hence Anuj was Amit's master for the said engagement. And the last option is none of the above. Okay, now let me explain this to you. So you can attempt to answer it if you want to, and you can write your answers in the chat box. So the principle, so firstly when you go through the principle, the first principle says master is liable for the acts of his servant done in due course of employment. Okay, now skip the second principle, go to the third one, because the third one tells you who is a master. The third one is saying master is one who controls and supervises the work of the servant. Now again, let's go to the fact situation. We'll come back to the second principle later on. So if I explain the fact situation in a simple manner, so Anuj is Anil's friend. Anuj requires a driver. Anil lends his driver to Anuj. Now Anuj tells Amit, the driver, to drive at a speed not above 80 km per hour. He also gives him an allowance and tells him to go to various places. So basically he gives him directions and control and supervises the work he does. Now despite Anuj's express prohibition, Amit still drives at a higher speed and ends up hitting a rickshaw driver. Now master is liable for the acts of his servant done in due course of employment. Who is the master? Master is the one who controls and supervises the work of the servant. In this fact situation, who is the one who is controlling and supervising the work of Amit? It is not Anil, it is Anuj. Anuj, the person who has been lent the driver to. Because Anuj is the one who is telling Amit to go to various places. He is the one who is telling him to drive at a particular speed. He is the one who is giving him an allowance for that particular day. So therefore, Anuj is the master in this particular case and not Anil, because Anil has just lent his servant. Anuj is the one who is giving him directions, who is controlling and supervising his work. So therefore, option C is the right answer, wherein Anuj is vicariously liable because he is the master of Amit in this particular situation. Amit is liable because he caused the accident. Now let us revisit the second principle. Express prohibition is no defense in vicarious liability. Now, when you look at option A says Amit is solely liable as he did not follow the express prohibition. So again, if you go to the principle, it's a straight enough answer. Express prohibition is no defense. So therefore, if something of this sort comes in your question paper, immediately you would eliminate option A, because express prohibition is no defense in vicarious liability. So therefore here it doesn't matter whether there was an express prohibition or not, the master would still be vicariously liable. Now if we come to option B, again you need to look at principle C, which says master is the one who controls and supervises the work of the servant. In this particular case, Anil is not the one who's supervising and controlling Amit, right? It's Anuj. So therefore again option B also gets eliminated. The left answer is option C and option D. Now again, apply first and third principles and you would understand that the one who is controlling and supervising Amit's work is Anuj, and therefore Anuj is the master, and hence Anuj would be vicariously liable, and at the same time Amit would also be liable because he is the one who caused the accident. So therefore C is the answer and D automatically gets eliminated. Now let us come to the second question. Now master is liable for the acts of his servant done in due course of employment. Now due course of employment includes authorized act done wrongly. Now Peter sent Sam, his servant, to buy groceries. Sam picked up a fight on the way and hit Anil. Now can Peter be held vicariously liable? Now first option says yes, as a master is liable for the acts of his servant. Option B says yes, as Sam was on his way to pick up the groceries and hence the fight happened in the due course of employment. Option C says no, the fight was not in the due course of employment and hence Peter cannot be held liable. And option D says none of the above. Now again, the principle says master is liable for the acts of his servant done in due course of employment. So what you need to check here is the ingredients. When is a master liable? A master is liable when his servant acts in the due course of employment. Now what is due course of employment? Due course of employment is an authorized act done wrongly. Now here Sam was sent to buy some groceries. Sam picked up a fight on the way and hit Anil. Now, was picking up a fight and hitting Anil within the due course of his employment? No. The authorized act was to go and buy groceries. If he did that particular act wrongly, then the master would be held vicariously liable. In this particular case, it was a detour. He was on his way to buy groceries. He picked up a fight and he hit Anil. Now this was not within the authorized act. The authorized act is not done wrongly here. It's a totally unconnected act. So therefore, the answer would be C, that no, the fight was not in the due course of employment and hence Peter cannot be held liable. That's right. Almost all of you have given the right answer. That's great. Now the third question. An independent contractor does not work on the directions and control of the person hiring him or her. So the person hiring an independent contractor has been defined as a principal here. Now the principal is not vicariously liable for the acts of an independent contractor. So now before you move on to the fact situation, so what do the principals say? The principle says, firstly, who is an independent contractor? An independent contractor is someone who does not work on the directions and control of the person hiring him or her. Again, second principle, the principal is not vicariously liable for the acts of an independent contractor. Now let us go to the fact situation. Amit hired an Uber. He got in the cab and told the driver to drive him to his destination. The Uber driver caused an accident. Is Amit vicariously liable? First option is yes, as a master is liable for the acts of his servant. Second option is Uber driver was acting under the control of Amit and hence Amit is also vicariously liable. Third option is no, an Uber driver is an independent contractor and hence Amit is not liable. And the last option is no, as Amit could not have foreseen the accident, the Uber driver is solely liable. Now let us go back to the principles. Who is an independent contractor? An independent contractor is someone who does not work on the directions and control of the person hiring him or her. Now if we look at the fact situation, is Amit giving him any directions or is he controlling the way the cab driver is driving? Is he telling him to control his speed or is he telling him to drive in a particular manner? No. The only thing Amit told him was to drive him to his destination, which is a very standard thing when you get in a cab. That cannot amount to direction and control. Now, the principal is not vicariously liable for acts of an independent contractor. So, if we establish that the Uber cab driver is an independent contractor, the answer is fairly simple that Amit is not vicariously liable as the cab driver is an independent contractor here. So, option C is the right answer here. Now, let's discuss one more question. So, the principle is master is liable for the negligent acts of his servant. Now, this is fairly simple. There's just one principle and there's just one fact situation. Now, Paresh was Mukesh's driver. He left the key in the ignition. Paresh's 20-year-old son Mahesh got into the vehicle and started driving it. He caused an accident. Is Mukesh liable? First option is only Mahesh is liable as he caused the accident. Second option is only Paresh is liable as he was negligent in performing his duty. Option C is Mukesh is vicariously liable as Paresh was his servant and he was negligent in performance of his duty. And option D is none of the above. Now the principle clearly says a master is liable for the negligent acts of his servant. Now again, if you look at the fact situation, the servant is Paresh. He has been negligent and hence the accident has been caused. So therefore, the master would be liable. The master here is Mukesh and therefore he would be liable and C would be the right answer here. So again, every time you get a fact situation principle based question, break down the principle, simplify it and ask questions to yourself in order to answer in terms of these principles. So like for example here, master is liable for the negligent acts of his servant. Ask yourself, when is the master liable? You can also read the question first and then read the principle. Maybe that way you would understand it in the context of the question. So therefore here the answer is C and yes, Mukesh would be vicariously liable here. Now let us come to some more announcements. So if you are in class 11, then we have a roadmap to your dream NLU. A comprehensive course on foundation module is going on to prepare students for CLAT 2022 and enrollments are on for the same. Now if you want to sign up for Gradeup Super, there are 3 subscription models. One is for 18 months, the other is for 6 months and the last one is for 1 month. If you have any course related queries, please call on the numbers given here. Thank you and have a nice day. Hopefully this session clarified your doubts on vicarious liability. Looking forward to more such interactions and interesting sessions. Thank you and have a nice day.